judgment in the matter of the Manchester Ship Canal Company Limited versus Vauxhall Motors Limited.
Lord Briggs will explain the decision of the court.
The well-known car maker Vauxhall has a large manufacturing plant in Ellesmere Port in Cheshire on the banks of the Manchester Ship Canal. When the plant was being built in the early 1960s, it was recognised that it would create a need for water and treated waste to be discharged into the canal. For this purpose, Vauxhall obtained from the canal's owner, the Manchester Ship Canal Company, a licence to construct a discharge structure of pipes and chambers called the spillway on the canal company's land between the Vauxhall plant and the canal, and to discharge water and treated industrial effluent through the spillway into the canal. Those rights were granted in perpetuity, i.e. forever, but Vauxhall agreed to pay the very modest sum of £50 a year for the rights granted. Clause 5 of the licence gave the canal company the right to terminate the licence if, among other things, the annual payment of £50 was not paid within 28 days of being demanded. This is what lawyers call a forfeiture clause. In early 2014, the £50 which had been overdue from the previous October was demanded by the canal company. Through an administrative oversight, Vauxhall failed to pay it, and the canal company then served notice terminating the licence under Clause 5. The market value of Vauxhall's rights under the licence runs to several hundreds of thousands of pounds a year. Vauxhall went to court to seek help in avoiding the financial calamity which its failure to pay a mere £50 threatened to cause. Whether the court can assist depends on whether the equitable remedy known as relief from forfeiture is available in relation to a licence of this kind. Relief from forfeiture is an ancient element of that part of the common law called equity. It has now largely been overtaken by statute, for example in relation to leases and mortgages, but it still has an important role to play in other areas. In general, equity modifies the strict application of the common law, where it would be contrary to conscience for it to be enforced to the letter. Equitable relief from forfeiture enables the court to mitigate the strict consequences of a contractual provision, where it can be seen that it was designed to achieve a primary objective, which can still be achieved when the case comes to court, but where the provision itself is inserted as a form of security for the achievement of that objective. In the present case, the primary objective was a small annual payment by Vauxhall to the canal company, and the company's right to terminate the licence was inserted as security, i.e. to make sure that the £50 was paid. There is no dispute that the provision in Clause 5 for termination of the licence is a type of forfeiture. But equity doesn't provide relief from forfeiture of any kind of right. In the courts below, it was common ground that the right in question had to be either proprietary, i.e. a form of ownership, or at least possessory, i.e. such as to give the holder of the licence effective possession and control of the spillway on the canal company's land. It was not suggested that the licence granted a proprietary right. Licences over land generally don't do so. Both the judge and the Court of Appeal found, however, that the rights granted by the licence were indeed possessory, and granted Vauxhall relief from the forfeiture of the licence upon payment of the £50 together with interest. In this court, the argument has become wider. The Canal Company argues, as appellant, that equity will only grant relief in relation to land from forfeiture of proprietary rights. Vauxhall argues, as respondent, that equity should grant relief from the forfeiture of any rights to make use of land or other types of property, even if neither proprietary or possessory, leaving the question whether to do so in any particular case as a matter for the discretion of the judge. The debate whether the rights granted by the licence were possessory has been argued in the alternative, in case it continues to matter. This court unanimously dismisses the Canal Company's appeal. 4 of us agree with the Court of Appeal that equity will only grant relief from forfeiture of proprietary or possessory rights, including rights over land, and that the rights granted by the licence were possessory because they gave Vauxhall effective possession and control of the spillway. I give the lead judgment. Our reasons are in outline as follows. 1. In order to preserve the much valued certainty of our common law in relation to business and property matters, equitable relief, including relief from forfeiture, needs to be seen to run in channels which are defined by reference to clear principles. Thus, to permit relief from the forfeiture of any kind of right to use property would be too wide, too uncertain, and would leave the outcome in almost every case to the merits-based decision of a particular judge. Secondly, recent cases since the early 1970s have laid down a clear and principled boundary for equitable relief from forfeiture, namely that the rights should be either proprietary or possessory. This is as true of rights over land as it is of rights over other kinds of property, such as ships, aircraft, trademarks, patents, video equipment, and shares, all of which have been the subject of recent cases. To confine relief from forfeiture over rights relating to land to proprietary rights would, for no good reason, restrict equity's role much more in relation to land, where the remedy originated, than in relation to other types of property. There is no principled reason for a different rule for land than for other types of property. Indeed, the identity of the thing over which the relevant rights are enjoyed is in principle irrelevant. The concept of possessory rights in relation to land causes no significant uncertainty as to the extent of equity's power to intervene, and the licence did grant possessory rights over the spillway for the reasons given by the Court of Appeal. Lady Arden agrees that the appeal should be dismissed, but for slightly different reasons.
Thank you. The Court will now adjourn.